Hi, this is attorney Mike Gravel. I'm coming to you from Chicago as usual. And today we're going to start another whole series. We're going to call this one Sovereign Citizen Court Fails Number 1. Let's do it.
As a
Not my obligation, and do not point
yes, you have a constitutional oath to uphold the Constitution now.
You have a constitutional oath to uphold the Constitution. The Fez is back and it's going to be fun. Hi, this is Frankie with the Sovereign Citizen Patrol, and I'd like to remind you to please hit like and subscribe, or I'll be personally offended.
You misunderstand procedure. I will attempt to explain it to you.
Objection.
The documents that you want are not documents that are in the court's file at this point in time.
Objection,
I don't know if they would ever be in the court's file at this point in time.
That's
Your
not,
position
that's
is,
not my problem, man.
Absolutely, it's your problem.
But that's
your
not my
position
problem.
is that you want them from the prosecutor.
Well, I haven't had a Fez in court since Sovereign Citizen Court number 17. Links in the description below. Also, I've made some adjustments. I have a new computer. I had a new mic, the last one, but this is a Tonor Q9. I'll put a link to that in the description below as well. But tell me if it's working better. I made a couple adjustments and hopefully I can get it there. But this guy's doing the same thing. I'm not sure if it's actually the same litigant or not, but he's already completely in contempt of court. He's objecting when the judge is trying to talk, and he keeps talking over her, but she seems to put up with it.
And you have requested them from the prosecutor.
That's right.
And the prosecutor has failed to give them to you.
That's right.
You can make the appropriate application to the court, and you can say to the court, I've asked for them, I'm entitled to them, I haven't gotten them, order them to give it to me.
I've already
I have
filed
received no
a notarized affidavit fact in reference to return of property weeks ago. A notarized affidavit. So if you're telling me you don't have to acknowledge affidavits, all right, that's what your statement is. However,
Okay, she won't, but I will. She doesn't need to acknowledge affidavits, especially when they're placed in filings that make no sense and don't comply with court rules.
bottom line is this court has held a true jurisdiction and has avoided the issue of jurisdiction at all costs. And nobody in here has a status. All right? Nobody has proven status, and nobody in here has the authority to proceed. Now, the last hearing we discussed, you stated that
Could you please stop yelling at me?
this matter, you stated, ma'am, for the record, you stated that this matter was relative to jurisdiction, not Mr. Keesler's position here, and not anything else. You stated that you were giving the prosecution a chance to prove jurisdiction, and he's not even the assigned prosecutor to the case, but obviously he's remaining silent, and he has nothing to state. So I move that this case be dismissed.
When there is an appropriate application before this court to address the issue of discovery violations, jurisdiction, or anything else, the court will act. Filing a notarized or not notarized affidavit is not an appropriate way to bring a matter before the attention of the court. What you must file is a notice of motion. It sets forth the relief that you want, and it needs to be supported with a certification, an affidavit, whatever it is.
Can you repeat that, ma'am?
Notice of motion.
She tells him he's got to file a motion. She says a notice of motion, but a notice of motion is just the notice. You got to file the motion too, and all this has to comply with the rules. And now he's taking that down like it's some grand information, which is just hilarious. But it is true. He would have to file an appropriate motion to have any of these things heard. Except he's now asking what the basis for that is. The basis can be the code of criminal procedure. I think this is a criminal matter in that state, and the rules of professional conduct. That's it.
This is exactly what I told Cheyenne Matoda Kushner L.
For the record, man, which rule, authority, courtroom rule, statute are you using?
It's in the court rules. I do not recall. It is in the court rules. I do not recall, and I'm not going to look up for you the exact court rule, but the court rules set out the procedure that you must follow.
Objection, man. I'm not a part of your society. I'm not subject to your courtroom rules, and you have not proven jurisdiction.
And I will never address the issue of jurisdiction until and unless the appropriate application is made before the court, because filing either an affidavit that's notarized or an affidavit that's not notarized does not bring it before the attention of this court.
Objection. There's no discretion to ignore lack of jurisdiction. Joyce versus United States. Jurisdiction is fundamental, and a judgment rendered by a court that does not have jurisdiction in here is void ab initio, and that is application of Y300P.132 versus Kagan. Once jurisdiction is challenged, the court cannot proceed when it clearly appears the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. Melo versus United States 505 F2D. When jurisdiction is challenged, the party invoked jurisdiction as the burden of status in Boston versus U.S. Power Light Company. Courts enforcement statutes do not act judicially but merely ministerially. Thus, no judicial immunity and unlike courts of law do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. I'm here by way of direct coercion. I'm going to make that clear for the record every time I have to appear. If I have to appear, the only reason I'm appearing here is by way of your direct coercion or your company's direct coercion.
Okay, this is really getting annoying. He just doesn't get the concept that you cannot bring an oral motion on jurisdiction here. There's a procedure, and that is namely that you would file a written motion on something more substantive like this, and there's a reason for that. That's that way opposing counsel can get it and respond to it. Typically, you would give them time to respond to it in writing and set up what's called a briefing schedule, and then set it down for hearing. And at that point, you would have a nice record if it goes up on review, and everybody would have a chance to make the appropriate arguments, and then the judge would make a ruling. Underneath, I can tell from what he's citing, it's all nonsense. The court has jurisdiction. He's wasting everyone's time, but he hasn't even gotten over the first hurdle of getting it before the court.
You can read me, let me interrupt you, please. You can read me this until the cows come home. You can read it ad nauseum and ad infinitum. It doesn't change the fact that until the issue is brought appropriately before this court, no ruling with regard to jurisdiction is ever going to be made. Now, let me ask you this question. In the other matter, first of all, let me backtrack a little bit. In the let me get the correct number out here because we have two numbers. In the case with indictment number 08-04-0441, which is the one in which Cheyenne and Cushionierel is also involved. I just severed those matters, so they will be on completely separate tracks. But he told me that he had filed a notice of removal to the federal court. And my question to you is, have you filed a notice of removal to federal court with regard to any of these matters?
Yes, ma'am. Notice of removal has been filed regarding all matters.
The three matters?
Yes, the three matters that
may I ask you, please, tell me, when did you file this?
They were filed last night. FedEx.
I filed it last night via FedEx, a motion to remove. I mean, I'm sure it's wrong and it's awful and everything else, but you know, the court doesn't have it. You know, maybe if you emailed it, but FedEx last night, no, that's not before the court yet.
To the federal court?
To the federal court.
Right.
Yes.
Well, as I am sure you are aware, if the court accepts them, then we will simply transfer them to the federal court. We won't deal with them anymore.
Okay, well, I'm still sure you're aware of the matter that you've not proven jurisdiction in either of the hearings and that you've avoided addressing the issue of jurisdiction.
And I will continue to not address the issue of jurisdiction until the appropriate motion is filed with the court and the court has the ability to address it and make a determination with regard to it.
And Judge, if I could just put in, that's the issue of James. As currently stands, we are representing.
Objection. You're not representing me.
Therefore, it would be our responsibility to file that motion. given the fact that he will not cooperate with our office, it's impossible for us to do that.
Objection.
We really need to.
Well, I want to get back to what I do want to get back to what Amir KCL said.
Wow, this is just fascinating to me. I've never been in this situation before in my life. I have clients. First of all, my clients never try to speak over me or address issues of law in front of a judge. I've never had it once in my career, so I don't even know what that feels like. Secondly, if they did, I would pull them aside and say, we're not doing this. You got to find another attorney. But this guy can't. The court has ordered that he's the attorney. He can't do anything. His client won't cooperate with him. It is just it is a crazy mess.
Now, we addressed the issue to some extent with regard to the indictments. I have here for you, and the record will reflect, that I am giving you a copy of the indictment that has 08-07-0727 and also 08-04-0441.
Objection. Just for the record, the Office of Public Defense does not represent me. You don't have any power of attorney for me, and I'm not part of your society, so you cannot represent me. We do not share nationalities. Okay, now, for the record, I need the nationality of every agent in here, and I need the name and information, because I'm suing everybody.
Mr. Kramer.
Everybody.
That's the best of the whole thing. I need everyone's name and nationality as if he's entitled to it somehow. And he's going to sue everybody. He's got no basis to sue anybody. I mean, he can, and he'll waste a bunch of money and get dismissed and probably get sanctions. But the chest thumping is hilarious.
So I need everybody's name and your position, starting with you, sir.
Who was calling out from the audience?
I was, ma'am.
No, you were not.
Who
was? No, do not hand anything over. Nothing. In the audience, please do not call out while court is in session, or the officer will ask you to leave.
Wow. Well, there you have it. That court hearing just going nowhere. I hate to criticize because everyone's trying to do what they think is right. If I was sitting on the bench, he'd be in contempt. He'd be in the lockup right now, constantly shouting objection while the judge is speaking, making no sense, going back to argument that makes no sense, and he's been told makes no sense, and not bringing it the proper form in terms of emotion. There's a limit to the tolerance on that stuff. His attorney can't control him, and he doesn't make any sense whatsoever, but he just keeps shutting everybody down. And also there's other things there. I didn't hear it, but she's referring to people saying things from the audience and trying to pass things back and forth. This is all a breach of courtroom decorum. This is not how it's supposed to work. Here at Law Talk, we do a lot of videos answering common legal questions. We also do reviews of law in the movies and then on TV. We also share some of our more interesting cases. We're always putting out new videos. So if you like that, please hit like, subscribe, and ring the bell.